Alright, thanks for joining us back here today. I have an interesting show planned for you gentlemen and gentlewomen today. I hope y'all enjoy it. The comment of the day is by John Labeless. Already have drafts for letters to be sent to them all. Thanks for confirming the places and whom to write. Phone lines should catch fire from an overload of calls. Thank you, John Labeless. You seem like a true blue co-conspirator. I really appreciate it. I'm also going to put some information about the action against Greg Newman, a sovereign citizen up in Hendersonville, North Carolina, who acts like a DA. So if people could give that some attention, I would greatly appreciate it, because that gentleman really needs to be out of there and prosecuted with criminal charges. So, what are we gonna do today? You know what? I ain't even set up my stuff. Look at me, I'm slack.
Battery 90%.
We're gonna do what we always do. We're gonna listen to some stuff and then we're gonna talk about it.
I cannot represent myself when I am present here today at court.
Mr. Vallejo, this is not a sovereign citizen action.
This is not a sovereign citizen action. What dang gum is a sovereign citizen? I mean, a sovereign's a king and a citizen's a slave. That seems like an oxymoron. Or maybe just you have to be moron to think that makes any type of sense. Anyways, look, I'm not a sovereign, I'm not a citizen, okay? God's not a respecter of persons, I just wish to be man. That's his image. But let's find out
According
what
to the
sovereign
Southern
citizen
Poverty
is.
Law Center, sovereign citizens believe that they, not judges, juries, or law enforcement, get to decide which laws to follow and which to ignore. Sovereign citizens are known for clogging up court systems with hundreds or thousands of legal filings. The filings are written in a nonsensical sovereign code, which most people can't understand.
However, a 2014 survey of law enforcement officers found that sovereign citizens were the #1 threat in the U.S., more so than even Islamic extremists or neo-Nazis. So what exactly is a sovereign citizen? The group is most known for pioneering techniques known as paper terrorism. This includes filing frivolous lawsuits, fake reports of tax evasion on government officials, and similar false documents. This forces their victims to spend time and money responding to these illegitimate claims, which sometimes even leads to bankruptcy.
Okay, so they believe they're above the law. They don't believe the law applies to them. They're terroristic in nature, and they do this thing called paper terrorism, where they put a bunch of paper into the court that causes terrorism upon their victims. I think I'm getting this so far.
Hello. Hello. What is the clerk of court? The clerk of court? I need to speak to the highest person in charge. Well, our chief clerk is in Winfield. The chief clerk is in Winfield? I should be able to access the court here. I don't know if I should be denied that access. So is there a place I can file a common law action? Here? Okay.
Now that absolutely amazed me. So she goes in there right off the bat. She's like, is there a place I can file a common law action? And the clerk immediately is like, here, right here. You know, I think that's probably one of the first times that's ever happened, that they were just so enthusiastic about it. Let's see what happens next.
What they're saying right there is that that's a cover sheet for a civil law action.
Am I demanding a jury on this one?
There's only one way to have a common law action. You can never ever have a judge in a common law action except to witness the jury.
So is there no way?
Okay, so I know I've gone over this before, but some people might be new to this channel, so I just wish to explain it one more time. Because of the separation of powers in our government, we, the people, have decided we're not going to allow the judicial power it's the power to judge us. Okay, the judiciary has judicial power. We just weren't going to allow them the power to judge us, which is why we are incredibly adamant in this country about trial by jury, which basically means that the judge doesn't do anything except witness the jury's verdict and what the jury decides. So whenever you have a real common law action, there is no judge. Let's see what happens
Way
next.
that I can file a common law action?
There is not even a thing called a common law action in the state of Kansas. We have common law marriages, but we have no common law action. There's nothing called that. So what is it exactly you're trying to do?
File a common law action.
I told you, there is no such thing as a common law action. Are you trying to sue an individual? Are you trying to sue a corporation? Are you trying to sue the government?
And
I'm sorry?
sue and summons an individual or person.
Okay, so that would be a civil action.
And I'm saying
It's
common.
not a common action. There is no such thing as a common action in the state of Kansas. It would be a civil action. It would be you versus another person. And that's what a caption for a case would be. We would need to know who the plaintiff is and who the
And
defendant is.
that's what I have here.
Okay, but
I
that's-
have the
No.
plaintiff and the defendant.
I'm telling you, that's not captioned correctly. The court cannot accept that. I mean, you can turn it. You can pay your fee, but it will just be rejected and you will have lost your fee. My staff has been trying to tell you that so you don't lose your money. You can go to the website that was provided to you, and it has the actual paperwork you would need to start a civil action. And you can use that, and then you have the correct paperwork with the correct caption, and you'd be able to get that filed. If you go to the kansasjudicialcouncil.org, those are free forms. That on there? Now, I will give you this information. No, you can refer to me as Judge Smith.
Okay, Judge Smith, if that's what used to be called.
Well, that was the position, sir, and again, I don't even know who you are or what.
I cannot.
Okay. Well, he was trying to convince her awfully hard that there's no such thing as a common law action, even though we all heard the clerk was like, yeah, we take common law actions here, until they saw the actual paperwork. Now, this comes from Corpus Juris Secundum, and it's talking about common law. It is generally described as those principles, usages, and rules of action applicable to the government and security of persons and property that do not rest for their authority on any express and positive declaration of the will of the legislature, which that would be statutory law. Okay? The type of law that does rest their authority upon the will of the legislature, the express will of the legislature. So, one of the things that they said describes a sovereign citizen is that they have this sovereign code, right? That they have this sovereign code. So, I'm going to read some of what Sierra was going to file. Okay. On Tuesday, February 2, 2021, the following facts transpired. 1. Unknown John Doe and unknown Jane Does left factually incorrect documents with no lawful adjudicated authority. 2. Unknown third party interlopes, trespass upon trust that God is the beneficiary of, I am the trustee of, and the offspring. The offsprings are the benefit. Okay? To raise Creator's children to be true and righteous women without molestation by state actors over plant substance said Creator creates. Okay. 3. I wish and require sacred trust between Creator and my offspring on be restored immediately. 4. Should Corey and other unknown actors refuse to restore sacred trust, consent to charge of $153.48 per minute per offspring, per actor or agency. That didn't seem so confusing to me. It didn't seem like a bunch of codes. It didn't seem like, I don't know, KSA 215609, whatever that means. But I'm sure it's worth taking your children. I'm sure. Now, Mr. Smith, Mr. Anderson, Mr. Smith seemed really, really eager to not let her file the common law action. He's saying he's trying to save her money. Well, I pull this from the Bill of Rights of Kansas's Constitution, and it says, Section 18, subsection 18. Justice without delay. All persons for injuries suffered in person, reputation, or property shall have remedy by due course of law and justice administered without delay. Doesn't say by due course of administration. It says by due course of law. Like, you go down to the courthouse, you make a claim, you pull in a jury, and you see what they think. Okay, now, as far as it goes with actual payment and him trying to save her money, see, here's the thing, is you go to some other constitutions, like North Carolina, Article 1, Section 18, courts shall be open. All courts shall be open, every person for an injury done him in his lands, goods, person, or reputation shall have remedy by due course of law, and right and justice shall be administered without favor, delay, or denial. Okay? Illinois, Section 12, right to remedy and justice. Every person shall find a certain remedy in the laws for all injuries and wrongs which he receives to his person, privacy, property, or reputation. He shall obtain justice by law, freely, completely, and promptly. And of course, all of this stuff comes from Magna Carta, subsection 40, where it says, to no one will we sell, to no one will we refuse or delay right or justice. Okay, so even like 800 years ago, people had already figured out, hey, government, you're there and you have courts for me and my rights. I'm not going to pay you for it. I'm not going to pay you for it because it's a right. Okay, now, you heard him say multiple times, there's no such thing as a common law action. No such thing as a common law action. There's never been any such thing as a common law action. Well, just because I like to mess with these people in their own words from their own state, let's go to McKeely versus Thompson, 2017. This is 2017. He said there was never any such thing as a common law action. Here's what the Supreme Court of Kansas had to say in 2017. We do not shy from our prior holdings that an intent to injure is a necessary element of the civil tort of battery in Kansas, but the precise nature of the injurious intent necessary to sustain a battery claim must be understood in light of the personal interest protected by the common law tort of battery. You mean that there's a civil tort of battery, and then there's a common law tort of battery? But you know what? The people who are sitting up on the Supreme Court of that state, they're probably just retarded, and I bet Judge Smith knows best. All right, this comes out of the Kansas Law Review, 2014. Domestic violence victims can use existing common law and statutory tort causes of action, such as battery, assault, and intentional infliction of emotional distress, to sue their abusers for abusive conduct. That's 2014. Not that long ago. The Lindemans were afforded an adequate state remedy under the common law tort claim of malicious prosecution and cannot seek relief under 1983. Although the abuse of process basis for the 1983 claim is not barred by the statute of limitations, Parrate precludes a 1983 claim based on abuse of process for the same reasons given for the malicious prosecution claim. So this is 1994 Supreme Court case, and they're saying that because the plaintiff already brought a malicious prosecution claim at common law, and because it's dealing with the same set of facts as the statutory 1983 claim, he can't bring the second action. Go imagine that. You got a common law action and a statutory action. Okay, this comes from American University Law Review, 2010. The plaintiff suffered injuries when her 18-year-old boyfriend accidentally shot her with a pistol. She brought a negligence per se claim against the vendor of the gun, alleging that the store had violated the Federal Gun Control Act of 1968 by selling a pistol to an 18-year-old. The court held that she did not state a negligence per se claim, but that a common law negligence claim could go forward. The Kentucky negligence per se statute only applied to violations of state law. American University Law Review 2010. That's an awful lot of legal resources showing that, yes, there's absolutely a difference between a common law action and common law claim and a statutory action and a statutory claim. And why is this? You want to know why it is? Because I know why it is. It's because you can't put all of the things that could happen into a statutory system. There's always going to be something or some way that happens outside of the idea of the legislature. And they just basically don't have the time to sit down and try and think of all of the ways somebody could be neglectful. So you have common law. They don't sit down and think about all the ways that somebody could commit fraud. So you have common law. It's really just that simple. Now, why would he be wishing to push this into a statutory civil action? I wonder. Because he is the individual that signed the fraudulent warrant, search warrant, fraudulent, obviously. And he's also the one who's been fraudulently keeping her children. Let's see what Cornell law has to say about tort. The boundaries of tort law are defined by common law and state statutory law. Judges interpreting the language of statutes have wide latitude in determining which actions qualify as legally cognizable wrongs, which defenses may override any given claim, and the appropriate measure of damages. So I guess if she does a civil lawsuit, a civil law action, the judge can just throw it out. That's what I just read. So, why do you think he's telling her there's no common law action? Probably because we don't have any law in this land. Now, let's go back to that whole sovereign citizen thing. Sovereign citizens don't think that the law applies to them. Obviously, this judge doesn't believe the law applies to him because, well, just look at what he's doing. He's not upholding her rights that are defined in the state constitution. He's completely lying to her about his duties and obligations as a judicial officer of the state. He's trying to push her into proceedings where he will absolutely have control over it. Okay, so that's one. Doesn't think the laws apply. Oh, they use some type of code system, sovereign code system that nobody can really understand. How many people have tried reading legal documents? In fact, legal documents are so complex, they tell you that you can't understand them and you can't read them. That's why they highly suggest that you get an attorney, is so that the attorney can understand how the court is screwing you for you and on your behalf. The attorney can understand how the court is taking your kids when you still have no clue. But, well, the attorney understands. So, they kind of got a mark on that one. And what was the last one? Oh, paper terrorism. You mean like stealing my children with pieces of paper? that is definitely a terrorist act. And here's the thing, people. Here's where it's at. The people who are taking Sierra's children and calling her the domestic terrorist also want to take your guns, your rights, make you pay for the privilege of having a gun, owning ammunition, being able to defend yourself, and then call you a terrorist when you believe you have some rights. That's all I gotta say. You trust who you wish to trust. And you can either worship some state statues, or you can follow the Creator and that man's law. I am just conspiracy, and I just wish to conspire to get Sierra's children back before they're dead. Because that's happened before. And only you can help me. Because we don't have any law in the courts anymore. Believe me. I've been walking through them for years. Anyways, if you wish to join me on this conspiracy, go check out the Telegram group. We'd love to have you. Get the conversation started. We got to get more people. And we'll see you next time. Peace.